One of the most discussed issues in the modern law of the sea is freedom of navigation operations, or FONOPs. What exactly are these operations and why do they generate debate? Freedom of navigation is a long-standing rule of the law of the sea. It means that ships of all states may travel freely on the high seas without interference, apart from limited exceptions recognized in international law. This principle evolved from custom into treaty law and was ultimately codified in the 1982 United Nations Convention on the Law of the Sea, or UNCLOS. UNCLOS preserved open navigation on the high seas while creating a system of maritime zones such as territorial seas and exclusive economic zones alongside concepts like innocent passage and transit passage. However, different interpretations remain, particularly over whether warships may enter certain waters without prior authorization. These differing views mean that navigation activities are perceived differently by states. Some see them as routine demonstrations of long-standing legal principles. Others view them as unnecessary or believe foreign warships should obtain prior consent before entering certain waters. FONOPs developed within this legal context. They are naval movements intended to demonstrate that states continue to exercise navigation rights where international law allows. The purpose is to prevent excessive maritime claims from becoming accepted through silence or lack of practice. Supporters view FONOPs as a practical way to reinforce norms embedded in UNCLOS. The South China Sea is one region where FONOPs have attracted particular attention. The United States conducts such operations worldwide through its Freedom of Navigation program. In the South China Sea, it uses FONOPs to signal its view that certain waters remain open under international law. China, however, maintains that some operations are inconsistent with its domestic laws and its interpretation of UNCLOS, especially regarding foreign military vessels entering specific maritime zones.